The Supreme Court.
Morning, everybody. Thanks so much. Please be seated. And before we start, good morning, Pages. Nice to have you here. When's the final exam? You got an exam, right? Huh? You do? Have you all signed in at the, up in the dome? Is there any, you haven't? Are you allowed to? You're not, you are allowed to. Justice Eden and I went up there once and did we find your name?
Oh, yeah,
We
I
did.
did.
All right, all right. Okay, well, it's nice to see you all. Thanks, thanks for your patience. Please go ahead and call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Amendment Number 1 to Fiscal Year 23 Accountable Care Organization Budget Order, case number 23 AP 290. Representing the appellant, One Care Vermont Accountable Care Organization, LLC, is Attorney Ann Rosenblum. Present with Attorney Rosenblum is Attorney Shap Smith. Representing the appellee, Green Mountain Care Board, is Attorney Patrick Gaudette.
Okay, thank you very much, counsel. Good morning.
Good morning. May it please the court, Ann Rosenblum of Dinsey on behalf of One Care Accountable Care Organization. The Green Mountain Care Board has conceded, as it must, that it doesn't have express statutory or regulatory authority to direct One Care as to the executive compensation it can provide to any of its employees. So the issue before the court with respect to executive compensation is whether there is some implicit authority for the Green Mountain Care Board to take that action.
I hate to do this so quickly, but I need to interrupt you. How is it we can provide any relief in this case? As I understand it, there was already a deadline that passed, I think, last fall. We're here talking about FY23. This is calendar year 23. Is that how it's based?
I believe the fiscal year for the ACO is on the calendar year.
Is on the calendar, that's what I assume. But here we're deep into 2024. How is it this court can provide any relief to you or to anybody in this case? And mind you, I understand neither party has raised this, but we're talking about an issue of subject matter jurisdiction, which under the rules is an issue that I think we have to at least acknowledge in the context of these proceedings.
I don't want to overstep my expertise as a lawyer as opposed to a member of the Accountable Care Organization's management, but I believe that the budget process isn't fully resolved precisely on the calendar year schedule. I think there's a settlement process that occurs after the fiscal year has concluded. So I don't know that the December 31st hits and the fiscal year is concluded and the issue becomes moot. But even if that were the case, the questions about the scope of the regulator's authority extend beyond fiscal year 2023. This isn't before the court on the record, but these questions about the scope of the regulator's authority to set executive compensation have persisted into the 24 fiscal year, and we expect will probably continue to persist beyond that.
Okay, just to be clear, you're not claiming monetary damages in any way, right? I don't see that. Okay,
That's correct.
thanks.
While you're interrupted, let me ask you about guidance 5.203A. Would you speak to that, and why doesn't that authorize what the board did?
I'd be happy to, and it's a good question. Rule 5.203A addresses executive compensation and provides that the accountable care organization, so One Care in this scenario, must have an executive compensation structure that aligns with the goals of the all-payer model, and that the Green Mountain Care Board must confirmed that that is true in reviewing the ACO for purposes of certification. Certification is confirming that OneCare has complied with the statutory criteria to do business in the state of Vermont. It's separate and distinct from the Green Mountain Care Board's responsibility to review and approve the ACO budget. The Green Mountain Care Board has blurred the line, so to speak, between the certification process and the budget review process. And invoking section 5.203 in the context of budget review is one example of how they're doing that. But the two processes are distinct. And in the budget review context, the Green Mountain Care Board is charged with considering administrative costs, which it has defined to include wage and salary data, but it doesn't have any broader or more granular power to examine the specific compensation provided to any employee and make a determination as to whether that's appropriate or unwarranted, as it's attempting to do here.
So Ms. Rosenbaum, now I have a question. I'll interrupt you. Can you just explain to me the structure of OneCare and how it works within the hospitals that it works with or the patients that it works with? 190,000 is in the printed case that are involved or under the jurisdiction of OneCare.
I can do my best. It's not a simple system, but OneCare is a not-for-profit organization that is a subsidiary of the University of Vermont Health Network, and it contracts with commercial payers and Medicare, federal payers, entities that pay for health insurance on behalf of Vermonters. And OneCare negotiates agreements whereby it receives funds from those payers and then provides it to participating providers to incentivize and promote innovations and improvements in healthcare delivery.
So it's a systematic approach to making sure that costs are contained within the medical system for Vermonters.
It is, and it's intended not only to contain costs, but also to do so by improving efficiency and changing the way that providers approach treating their patients.
So and providing efficiency means it has better buying power or negotiating power with, say, a commercial payer.
It doesn't assume the role of a commercial payer, but it.
Oh, I think they have to negotiate with the commercial payer, that they could negotiate reimbursement rates and the like.
It doesn't necessarily take on that specific of a role. It's really kind of a novel entity where it's trying to change the way in which providers are compensated for the services they provide. So it's an entirely different approach than fee-for-service, which is the traditional way in which payers compensate providers for healthcare.
And they're required to submit the budget to the Green Mountain Care Board as part of it's because of the numbers that it controls.
Yes and no. The Green Mountain Care Board, by statute, is charged with reviewing the ACO's budget, among other duties that the Green Mountain Care Board performs for entities beyond ACOs. And I think it's simply because of the unique role that the ACO plays in healthcare, healthcare funding especially, which is a matter of significant public concern.
So, Ms. Rosenblum, let's go to section 9382 then. 9382 empowers the Green Mountain Care Board in determining whether to certify or maintain certification of an ACO and to establish standards and processes for reviewing, modifying, and improving the budgets of the ACO. Factors that it can consider, there's a list of them. One of those factors is the ACO's costs and use on a proposed budget and information on the ACO's administrative costs as defined by the board. So I'm going to reduce this to the simplest terms because that's what I understand the best typically. A budget is money coming in and money going out. If money going out covers the salaries of the executives, why is that not implicitly then within the authority of the Green Mountain Care Board to review?
The modification authority that the Green Mountain Care Board has would be to direct OneCare, your budget as a whole, the money going out is too substantial and we think it needs to be reduced. From that point on, The role of OneCare's Board of Managers is to determine how it can operate the business while complying with the budget set by the Green Mountain Care Board. When the Green Mountain Care Board reaches deeper into the budget and begins to direct specific expenditures and announce its own evaluation of whether a particular expenditure or cost is appropriate, it's usurping the role of the Green Mountain.
Are you saying that they don't have any authority to critique even line items in the budget that's proposed?
I think there's a distinction between critiquing and ordering OneCare or ordering OneCare to cap an expenditure or to modify it retroactively, which is what they did here. There's a good example within the same record of the way this might work, which was earlier in the same budget year, the Green Mountain Care Board directed OneCare to reduce its administrative expense budget by 2%. And OneCare did that and complied with that directive in its next budget submission. It might have, the OneCare's Board of Managers could have looked at that directive and said, we can't meet this directive and still achieve our organizational objectives. But in that instance, the OneCare's Board of Managers looked at the directive, voted to approve that they could do it, and determined that they could do it without cutting executive compensation, which is what they did. In fact, the revised budget they submitted exceeded the target set by the Green Mountain Care Board. And that represents a more appropriate division of responsibility and labor between the Green Mountain Care Board and the Board of Managers for OneCare.
So it's your position that the modification to the aggregate cap didn't solve the problem?
It doesn't. I think the Green Mountain Care Board hopes that that would be true, and I think that might be based on their interpretation of the Green Mountain Tower case from this court. But the effect of the Green Mountain Care Board's condition here is that somewhere between 1 and 5 OneCare executives are no longer eligible to receive the compensation that they agreed to accept when they accepted their positions for financial year 2023. And it also represents the Green Mountain Care Board's judgment that the compensation that had been agreed to for those employees was unwarranted or inappropriate. And this court has held that that is not the role of a regulator to make that determination. I'd like to also address the Green Mountain Care Board's argument that OneCare's arguments in this appeal are not preserved, because that also is kind of a threshold issue. And I think if you take a look at the public comment that OneCare submitted during the only public comment period that was held on this budget amendment, OneCare clearly raised the issue of whether the Green Mountain Care Board had complied with its procedural obligations.
I'm going to interrupt you for just a moment. I apologize. I just want to make sure that I'm thinking about the same thing you're referring to as the comment. Is that the August 8th comment?
It is the August 8th.
Thank you.
That's right.
And can I ask a question about that
Yes.
before you go on? I realize they made a comment, but it wasn't, there was no law cited, no statutory language, no rule language, nothing cited there. So how is it preserved when we've held that a one-line statement doesn't satisfy the preservation requirements?
Not to quibble on details, it was more than one line, but to your more direct question, I see that my time is up, but I'd like to finish responding to your question, Your Honor. The comment raised the issue sufficiently to put the Green Mountain Care Board on notice of OneCare's objections. And that is the purpose of preservation, is to give the tribunal or the administrative agency or the lower court the opportunity to address the issues before it issues its ruling. And the Green Mountain Care Board had that opportunity here, which is confirmed by the discussion in the dissent of many of the issues that are raised in this appeal. I will reserve the rest.
Okay, thanks very much. We'll hear from counsel for the appellee. Please come on up. If you would introduce yourself and identify your client as well. Yep,
Good morning, AAG Patrick Audette for the Green Mountain Care Board.
thank you.
I'd like to start where the court just finished on the issue of preservation very briefly. The board's position is that none of the issues in this appeal have been preserved, and thus that the court may dispose of the appeal entirely on that basis. regarding the Chief Justice's question on mootness, opposing counsel's argument and response was essentially a capable of repetition yet evading review argument. However, that, as the court noted and opposing counsel noted, the whole mootness issue has not been thoroughly briefed. The board's position would be that this case is moot at this point.
But you didn't raise it.
That's true. But to the extent it's being raised now, just to provide insight, that would be the board's position. I'd like to spend most of my time this morning talking about the compensation cap condition, the hospital attestation condition, and the due process which was afforded to OneCare before these conditions were imposed.
You just mentioned preservation, though, in your introductory comments. Can you talk about that first?
Certainly. So the issues raised by OneCare can eventually be divided into two categories. There are those issues which are raised in passing in the 112-word comment that they submitted on August 8th, and there are those issues that were entirely unmentioned before the board at any point. So in the first category, you have issues which run into the challenge, Justice Carroll, that you noted, which is that single-line explanations are generally inadequate to preserve an issue. And this court held that very recently in Ray Apple Hill petition, where the court held that even constitutional arguments, even with the use of specific constitutional language, are not preserved just by invocation of that constitutional language. So regarding the impact of the dissenting opinion mentioning these issues, as the board cited in its brief, State v. Davis stands for the proposition that even where a lower tribunal mentions an issue or sua sponte considers an issue, that does not necessarily mean that the goal of the preservation rule has been satisfied, because the parties have not necessarily been able to provide evidence and argument. As in State v. Davis, where this court held that the trial court was not necessarily aware of those objections, the same is true here. The dissent was not necessarily addressing specific objections made in detail by OneCare. It was addressing issues that arose to it. So those issues that are mentioned only in the comment are inadequately preserved, partially because of their lack of detail, but also the modification to the revised budget. Those conditions were announced June 14th. And the board's process is a little unusual, where they have a public meeting, they vote on the budget under review, they decide what conditions to impose at that meeting, and they vote on a Robert's Rules motion at that meeting. But the eventual detailed budget order does not come out until significantly later. And so you can see that both in the timeline of the process on the initial budget order and in the timeline on this modification, where the final order didn't come out until August 9th.
Yeah, but the only modification in the August order was to condition 2, I think, right? The condition 1 was not modified. The PCP affidavit condition was not modified.
Correct. So that condition was never modified, but both conditions were announced in some form for the first time at that June 14th meeting, when they were imposed following a board vote. But they don't appear in a formal opinion.
So where does the appeal period begin to run, in your estimation, as to condition 1?
As to condition 1,
Are you arguing that aren't you arguing in some respect that the appeal was out of time? The notice was out of time?
Not quite, Your Honor. The board's argument is that neither issue was preserved, and the time for appeal would run, I believe, not from the motion at the meeting, but from the issuance of that detail.
So you would concede, just to be clear on this record, you're conceding that the notice of appeal that was filed by the appellant was timely?
Yes.
Right? Okay. Thank you.
Yes. Regarding the other issues which are totally unpreserved, there is not even an argument to be made that there's somewhere in the record they were mentioned. The contracts clause appears nowhere below. Mostly the contracts clause is what is fully unpreserved, even though The due process arguments, the point made in that 112 word comment is that there's a disappointing lack of regard for procedural fairness, which is not a legal argument. It's not an assertion that one care's constitutional rights were prejudiced, and it's inadequate to preserve the issue. Regarding the compensation clause, it is true that there is no express language in 9382 or the board's regulations which provide that the board may directly set individual line items in a budget. However, budgets consist of line items. Once you add all of the line items up in a budget, you have the top line of the budget, but all it is a set of line items, and any modification to a budget is necessarily going to modify those line items. OneCare's position that the appropriate division of labor is for the board to reach some conclusion and then refer it back to OneCare, as they did in the December order, is certainly one way for things to be done, but it is not what is legally required. Wherever the line falls in terms of the appropriateness of an agency modifying executive salary, this court has already addressed the issue in Letourneau and In re Green Mountain Power Corp. And of the two, this case is much more closely analogous to In re Green Mountain Power Corp. This was not the board setting one individual salary. This was the board imposing an aggregate cap on salaries, which is directly analogous to the cap on salary increases imposed in re Green Mountain Power Corp. After all, if you know current salaries and impose a cap on increases, that is fundamentally identical to capping salaries directly. Regarding the issue,
Would that be an inherent authority of the Green Mountain Care Board?
so it is not inherent to the board qua board, but it is inherent to the board's power to modify budgets, to consider administrative expenses, which are defined to include wages and salaries.
And what authority is it to say this is inherent powers within an administrative agency?
So this court previously addressed the issue as discussed in the brief that I believe it's In re Vermont Health Service Corp. Which is also cited in the brief for the proposition that where an agency has the authority to consider a particular factor and is directed to issue something to address that factor, it has the inherent or implicit authority to adjust that.
So but the Green Mountain Care Board, they're looking at whether or not to approve or not approve. They could just say, we're not approving this budget because of X, Y, and Z.
That is
not put the caps in. I mean, that's part of its responsibilities, not?
Is what part of its responsibility?
Part of its responsibility, they look at the budgets and say whether or not it's appropriate or not appropriate.
So the specific statutory authority in 9382B is to approve, reject, or modify. And so the board is expressly statutorily empowered to modify budgets. And here procedurally, OneCare actually moved for this modification. OneCare initiated this process by requesting a budget modification following the board's conclusion that their budget, which had been approved, was out of compliance based on the BCBS agreement falling through.
Are you suggesting that the authority to modify necessarily implicates a line item?
Yes, and I think that there is a separate doctrinal line in cases such as the Turnout and In re Green Mountain Power Corp, where there's a concern about the private entities, essentially in an analogy to the business judgment rule, their ability to manage their own affairs. And that concern is in the wings. But again, this court has held that imposing an aggregate cap on salaries is acceptable and is not falling the wrong side of that line.
But didn't OneCare make the certification contingent on, I'm sorry, Green Mountain Care Board made their certification contingent on OneCare coming in under that budget, right?
So not quite, because the certification and budget processes are different. And here we are in the budget process.
But if they don't come in under that budget, then they lose certification, correct?
At a certain point, yes.
So help me understand that distinction, because I would imagine certification is really important.
I think that OneCare and the board would agree with that, and I'm happy to agree too. The difference is that it's essentially that they're different processes. The application for the budget is different. The factors which are considered by the board and the procedural steps which are imposed are different in those two processes, for example, and they're governed by different rules in the board's regulations.
So that's the difference between, is it 5.2 and then 9382?
93 and 82 is the statute, is,
That confers.
yeah, it's the statutory provision. 5.2 is certification, 5.4 is the budget process.
Okay.
And so,
Mr. Bennett.
5.407 permits the board to modify budgets on application. Here, OneCare made that application. When the board is considering a application for modification under 407, it is specifically empowered to consider 9382 factors, as well as any other factors the board considers appropriate. And here, the board considered the factors generally applicable to budgets, including a concern for financial responsibility and competence, and the adequacy or sufficiency of the administrative expenses which are being imposed. The opposing counsel pointed out that when the board begins to direct specific expenditures, that's when the board is exceeding its authority, and that is essentially what LePernau stands for. Here, however, the board was not directing specific expenditures. It was imposing a cap on an aggregate category based on the concerns that were supported by the evidence. Regarding the adequacy of the notice afforded to OneCare, the requirement is that OneCare receive notice sufficient to avoid unfair surprise. And this standard is applicable both under the Administrative Procedure Act and under the Due Process Clause itself, which is also discussed in the board's brief. Here, OneCare was not subject to unfair surprise. OneCare essentially argues seeking much more specific notice than this court has held is actually required. This court specifically held that parties are not entitled to notice of every potential supplemental order, which analogously here, parties are not entitled to every potential modification which the board may issue.
So, Mr. Gaudet, because the board had provided notice for a potential vote on the amended budget on either June 14th, or it was placed on the June 14th agenda, and then the August 2nd, but the vote actually took place on August 9th, that's enough to give notice.
So here there were two votes. There was a vote on, I think the very first agenda you'll see OneCare is May 31st, but they were bumped to June 14th. At June 14th, the board voted to approve the budget subject to these two new modifications, as well as the initial budget orders attached to the board's brief. There are 15 other modifications. That was the June 14th vote. The August 2nd meeting, the chair raised before the board, essentially, it looks like condition 2 is ambiguous. It isn't clear if it's individual or aggregate. I'm going to raise a motion next week. We'll vote on it. And then August 9th, the board revisited the issue and clarified the wording.
Making clear those aggregates.
Yes. Yes. So those are the two votes. June 14th, though, is when the modification was first imposed.
And August 8th, OneCare sent in a response.
Correct. OneCare waited almost 2 months before submitting the comment that they ended up submitting. Another thing on the inherent authority, this court held in Vermont Health Service Corp. That the notice was of a statutory provision, 8 VSA 4513, and was in the context of a rate setting process. Analogously here, OneCare knew that this was a budget modification process. OneCare itself actually asked for this budget modification process to begin. Analogously in Vermont Health Service Corp., where notice of a 8 VSA section 4513 proceeding also provided notice that there may be supplemental orders issued. Here, the fact that OneCare requested modification of its budget and the board actually went ahead with that process of budget modification indicates that their budget would be modified or potentially could be modified, which is all that was required for fair notice to be given. Thank you.
Okay, thank you. How much time does the appellant have, please?
Helen has 2 minutes and 25 seconds remaining.
Okay.
There are 4 issues that I'd like to address as fast as I can. And the first one is the just a factual issue that was raised represented to the court that OneCare requested this amended budget process. And that is technically true, but it did so at the Green Mountain Care Board's direction. So this was not a scenario where OneCare said, you know, we really need this independently of the regulator directing them to take that action.
But there was no objection to it.
There was no objection. OneCare throughout this process has attempted to cooperate with its regulator. Secondly, this is relevant to both notice and preservation. The compensation condition and the hospital oath condition were introduced at a public hearing on June 14th and voted on and approved and made part of the amended budget at that same meeting. And from OneCare's perspective, that was a final decision. The Green Mountain Care Board's budget review rules don't outline or preview the fact that the Green Mountain Care Board might come back to a vote that it took before it issues its written decision and make a modification to it. And there's also not a specific deadline for when the Green Mountain Care Board is going to issue its written ruling. So OneCare didn't have any basis to know that it could object or should object, or that it could ask the board to revisit this condition. Finally, I'd like to address the holding of Letourneau because it is critically important here. In Letourneau, this court found that the Public Service Commission or Public Service Board had implicitly made a finding as to the appropriateness of an executive's salary and determined that that was the province of management and not the role of the regulator. And although the Green Mountain Care Board is seeking to take itself outside of that holding by imposing the compensation condition on an aggregate basis, if you look at the findings that it cites in support of that condition, it has made a determination that this compensation that OneCare's Board of Managers allocated for those executives was inappropriate or unwarranted for financial year 2023. And that looks much more like the determination that this court found was an overstep and an overreach of regulatory authority in Letourneau.
Chief, can I just ask one quick question?
Yeah, please. Yeah.
Ms. Rosenblum, what's the importance of having an aggregate amount of compensation where now your client could then make internal decisions as to how salaries should be distributed?
It's true that there's a modicum of discretion that's left to OneCare's Board of Managers if they're forced to comply with the compensation condition, but there's no dispute that the Green Mountain Care Board based its decision on a determination that the compensation these employees were going to receive was too high, so that's substituting its judgment. And the Green Mountain Care Board, OneCare cannot comply with this condition without cutting the compensation that at least one, if not 5 employees are going to receive.
Thank you.
Thank you.
Thank you very much. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 9:45.